Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about this article from Jackson Lewis. Jackson Lewis is a human resources employment law firm. It's a pretty good one, so check them out. You can check the link down below. And it says that the National Labor Relations Board is going to keep an eye on employee surveillance. And you can check out our other video about this where actually with employer surveillance, they were actually able to recoup some of the money effectively stolen from them. And I think that's really interesting. Now that case was in Canada. This is coming out of the National Labor Relations Board of America. And many employers who are who have remote employees are starting to use ways of tracking performance and productivity, and as a result they're looking at employee keystrokes and key screenshots and on-camera requirements for employees during work hours. And so what's interesting is that the general counsel, the lawyer for the National Labor Relations Board, is interested in this, which is interesting. So the National Labor Relations Board governs unions and unionization in the United States, and they often take a pretty broad strokes approach to many labor laws to favor unions and unionization. And there's a lot of really interesting case law with respect to this. But the general counsel for the National Labor Relations Board says that an issue of particular concern is the potential for omnipresent surveillance and other algorithmic management tools to interfere with the exercise of Section 7 rights. Now, just to be clear here, Section 7 rights are rights for employees to unionize. So effectively what the general counsel is saying here is that the company could, spy on employees and as a result know whether or not they're unionizing, which is true, right? It is an accurate statement to say that, right? And if they're violating Section 8A by putting in new monitoring technologies in response to union activities, it could result in spying, and there is a very specific rule against employers spying in with respect to unionization and what they call protected activity. So that is a well-known and it is against the law. And so the general counsel is asking the National Labor Relations Board to look at a larger concept of determining whether or not monitoring employees through electronic means is lawful because it could prevent organizing efforts. Furthermore, the general counsel encourages employers to sort of reduce their amount of surveillance. So what do I think, if anyone cares? I think the interesting thing and the problem here is that the more laws like this seem to be inflicted on, or the more controls that you see on the workforces that are working from home, the more likely that you may see remote workers just being contracted to foreign countries like India and things of that nature. There, water always chooses the easiest path, right? And that's what you'll often see, and that's why I really don't typically believe that these types of ideas actually protect the worker. It's great, it would be great, I suppose, but what it also ultimately means is that if employers can't manage the work of their employees, they're gonna figure out a way to do so, and they'll probably do it, especially from jobs that can work from home. They'll just outsource them to India. It's why you see a lot of payroll and recruiting functions that were typically in-house HR functions being outsourced to India and the Philippines, etc. I'd like to know what you think. leave a comment down below, and always like, share, and subscribe, and I'll see you on the next one. Bye, guys.